Hello and welcome. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And thank you for being with me today. Today, I want to talk about consular processing with a waiver. And really, I'm only talking about unlawful presence waivers on the I-601A. But start to finish, what does that process look like? All right. And so, and I don't want to talk too much about eligibility, although eligibility is a fundamental issue. So do a consultation with an attorney who knows this stuff before you start the process to make sure of two things. One, to make sure that you're eligible to do this process, and two, to make sure that this process is actually the best one for you, all right? Sometimes an adjustment of status, if you're eligible for adjustment of status, like for example, if you were admitted or inspected or paroled or waived through the border to enter the United States, you might be much better off doing an adjustment of status case rather than going through the waiver process and processing your case in a consulate overseas, all right? But so do a consultation with an attorney to get you the eligibility and the advice as to what strategy, what process is best for you. And then after you've done that, if the best process is the consular process with a waiver, let me talk to you about that and let me walk you through the process, all right? It's basically a 3 big step process. Step number 1 is what we call the petition, all right? So imagine you're married to a U.S. citizen, for example. A U.S. citizen has the right to file a petition for a foreign national spouse. And so that's the first step. And what does that petition say? It says 2 things. First, it says that the U.S. citizen is in fact a U.S. citizen. Second, it says that the foreign national and the U.S. citizen are in fact, in law and bona fide, quote unquote, married. All right. And that's why we like to document your relationship. We like to show that you're not just married by law, and yes, we got to attach the certificate of marriage, but we've also got to show and to prove the bona fides of your relationship, show that you are a legitimate couple, that you really love each other, that you're not actually just doing this solely for immigration purposes, all right? And so that's that, and that's step 1. It's the petition. You send all of that in an application off to USCIS. It takes several months, up to a year, sometimes longer than a year, to get that petition approved. Then once that petition's approved, you can go to step 2, all right? Step 2 is the I-601A waiver. You can only do an I-601A waiver if your only inadmissibility issue is the unlawful presence that you've accrued, because the way it works is when a person leaves the United States after having 365 days of unlawful presence, they would trigger a 10-year bar, all right? Well, the I-601A allows a person to get a waiver of the 10-year bar before they leave to consular process their case. It's actually really great that we can do that, and we didn't always have, the I-601A was created in regulations, I think, in January of 2018 under the Obama administration. We used to have to leave the U.S. to process this. And so now we can process it. We call it a stateside waiver, or we call it a provisional hardship waiver. And so that's great. If you only have unlawful presence, and that's the only kind of issue, red flag problem in your case, then you can waive that. And how do you waive it? All right, so to waive it, you've got to show 2 things. You've got to show that you have a United States citizen spouse or a green card holder, spouse or parent. That's 1. You got to show you have a U.S. citizen or green card holder, spouse or parent, not children, spouse or parent only, who would, and number 2, who would suffer extreme hardship, all right? Not just any level of hardship, but it's got to be extreme hardship if your petition were denied, if your waiver were denied, if you had to be outside the United States for 10 years and live out the 10-year bar, all right? And so that's the biggest part of the case, really. It's the hardest part of any of these cases. We've got to show extreme hardship to a U.S. citizen, spouse, or parent. So how do we do that? We talk about financial hardship. We talk about emotional hardship. We talk about medical hardship. We talk about safety concerns. We talk about anything we can possibly think of, and we document it. And in our office, a waiver is like, it's a small book, right, that we've put together to explain to immigration all the reasons why you guys can't be separated for that long, all right, and how the U.S. citizen or the green card holder would suffer if your case were denied, all right? So that's the waiver. After the waiver's approved, and then you mail that off, that can be pending for a year or longer, all right? Then after that's approved, then we've got to deal with the National Visa Center, all right? And really step 3 is the whole issue of the consular interview. And you can break that piece up into many different steps. But basically, we've got to follow up with the National Visa Center. We call it the NVC. We've got to file your DS-260. We've got to pay the fees. And actually, we had to pay those fees before even filing the waiver to begin with. And we've got to submit your sponsorship packet along with your declaration of self-sufficiency. So your I-944, it's no longer that, it's the DS-5540. I think that's the number of form. But basically, you've got to show the finances. You've got to have a sponsor that's showing their tax returns, things like that. And you've got to put a packet together to explain how you're not going to be a public charge on the government. We send all that off to the National Visa Center. Then we coordinate, after we get through that, we coordinate the interview at your home consulate in whatever country you are from, all right? And there is a way to do third country processing. Talk to a lawyer about that, all right? And then we schedule the interview. So once your interview gets scheduled, now you're going to be leaving the United States. You're going to go back to your home country. You're going to have a medical exam in the country. You're going to show up to the interview at the consulate in your country. They're going to see that the petition was approved. They're going to see that the waiver was approved. You're going to walk in our office, we send you with a binder of everything organized that you're going to take with you to your appointment, all right? And so, and that officer is going to ask you questions about your admissibility, which is why you want to make sure you're eligible even before beginning this whole process. And they're going to make sure that everything, the petition, the waiver, was all done properly. And then if everything goes well, all right, and if you're not inadmissible, see our other videos about inadmissibility, all right? If you're not inadmissible, if you're eligible, if everything looks good, they will put a stamp in your passport that will allow you to get back on a plane or to cross and to be readmitted into the United States. And then you pay what they call the Ellis fee, and then they mail you your green card. That is the full process to get a green card in the United States. These are complex cases. When there's waivers involved, they're complex. When there's leaving the United States and processing it at a consulate overseas, it's complex. You're going to want a lawyer to help you through this process. My purpose today is just to explain step by step, and we have lots of clients that are going through this. We've won lots of these cases. I'd love to really walk you through it step by step as well. Hope this video was helpful. If it was, please give us a thumbs up or please subscribe to our channel here on YouTube. We do lots of waivers, and so if you've got questions about waivers, please feel free to call our office. Thanks so much for watching. I'm Otis Landerholm, Landerholm Immigration, A.P.C., where we fight for your American dream. Thank you. Bye-bye.